The facts matter.
Good morning, everyone. Virgo here. It is November 19th, 2020, and guess what we're going to do? We're going to have some fun going over this crazy case that was filed by R. Razak Rashid Bey, where I provided to you the 27 summons video day before yesterday, where everybody got a chance to see him going up to everybody and saying, "You've been served." Here's the case. I located it after I did the video. It is in Pacer, and he really did file it. And I think you guys are going to find what he filed amazingly interesting and entertaining. So we're going to be taking a look at this document with a fine-tooth comb and give you guys all the opportunity to have a little bit of fun. All right, here we go. So the case number is 120CV365. You can locate it in Pacer. You can also locate it on Court Listener. I will link all of the links to the information in the description of the video. So here we go. So this is what was originally filed on October 19th of 2020. And make no mistake, this is not his first rodeo. So he has already been through this a few different times, had his cases dismissed and all kinds of crazy stuff, but apparently has not learned a thing. Please notice on the right-hand side the appropriate postage stamp of 2 cents with the red thumbprint and his signature across it diagonally. Very April LaJune of him. Here we go. The Moorish National Republic, Moorish Divine and National Movement of the World, Aboriginal and Indigenous Natural Peoples of Northwest Amexem, North America. In the United States Supreme Court for Indiana Republic. All right, and as you can see, this is the same party. Authorized representative natural person in propria persona. All rights reserved. UCC 1-207, 1-308, UCC 1-103, which means absolutely nothing, even though they claim it does. Not a corporate person or entity misrepresented by the fraudulent construct of all capital letters. Indiana Territory. All right, here we go. Petitioner. Kokomo Mayor Tyler O. Moore, and then it goes on to name all 27 others. All right. And we're going to talk about jurisdiction here. Here we go. This action containing complaints for declaratory relief and for damages is brought against the defendants to secure due process of law, equal protection, and other rights, privileges, and immunities guaranteed to complainant by the Constitution/treaty and laws of these United States Republic. Jurisdiction of this court is invoked under the Zodiac Constitution, copyright AA 222141. I could go into what that is, but let's just say that it has a lot to do with a person named C. Cannon Bay, and it means nothing in terms of the courts. Liberty of Congress, Washington, District of Columbia, Constitution/treaty, and laws of the United States Republic as follows. The Zodiac Constitution, Article 1, 2, 3, 4, 5, 1, 2, 3, 4, 6, and 7. Indiana State Constitution, Article 1, Bill of Rights, Section 1, 2, 9, and 12. 13, 19, 20, 21, 22, 24, 26, 28, 30, 36, and 37. United States Republic Constitution, Article 3, Section 1, 2, Article 4, Section 1, 2, 4, and Article 6, Universal Declaration of Human Rights, and Article too many for me to say. It doesn't matter anyway, because none of this is recognized. Venue, original jurisdiction, United States Supreme Court of Indiana. Plaintiff. R. Razak Rashid Bey, natural person and propria persona sui juris, not to be confused with nor substituted by pro se, by unauthorized hand of another. I am aboriginal, indigenous, Moorish American, possessing freehold by inheritance, and primogeniture status, standing squarely affirmed, aligned and bound to the Zodiac Constitution, with all due respect and honors given to the Constitution for the United States Republic, North America, being a descendant of Moroccans and born in America, with the blood of the ancient Moabites from the land of Moab, who received permission from the pharaohs of Egypt to settle and inhabit Northwest Africa / Northgate. The Moors are the founders and are the true possessors of the present Moroccan Empire, and are Canaanite, Hittite, and Amorite brethren who sojourned from the land of Canaan, seeking new homes. Our dominion and inhabitation extended from northwest and southwest Africa, across the great Atlantis, even unto the present North, South, and Central America, and the adjoining islands, bound squarely affirmed to the Treaty of Peace and Friendship of postage stamp of 1836 AD between Morocco and the United States. And then he, of course, has to put a link there because, after all, that's, linkable on a sheet of paper. The same is displayed under treaty law obligations authority as expressed in Article 6 of the Constitution for the United States of America Republic. So do you guys remember a video that I did last week where the USAR, which is the group that were doing the scams with the text messages that were like the Nigerian 419 scams? That's the same group, by the way. All right, here we go. So the Treaty of Peace and Friendship of 1836 AD between Morocco and the United States. Article 20. If any of the citizens of the United States or any persons under their protection shall have any disputes with each other, the council shall decide between the parties. And whenever the consul shall require any aid or assistance from our government to enforce his decisions, it shall be immediately granted to him. Article 21. If any citizen of the United States should kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place, and equal justice shall be rendered, the consul assisting at the trial, and if any delinquent shall make his escape, the consul shall not be answerable for him in any manner whatever. I want a brownie button for reading this, you guys, when I'm done. All right, we talk about the defendants here, and all 27 of them, and the facts. In support of this petition, I state for the record, number 1, an invitation dated 9/31/2020 was received from Superior Court 3 in regard to a claim made by policy enforcer Justin McKay. Number 2, on November 2nd of 2019, a writ in the nature of discovery was sent certified mail return receipt to Clerk of Superior Court 3, requesting certified and verified official copies of certified delegation of authority order, oath of office, oath of ethics, and bond number, so I could make a physical inspection and verify and witness the same. This was a lawful demand and request under the rule of discovery. It was further stated to provide the information within 10 days of the receipt of this notice of discovery. Number 3. On November 7th of 2019, Clerk of Superior Court 3 received the writ in the nature of discovery, jury trial of my peers, Moorish Americans. Number 4. On November 18th, 2019, I made a special appearance to clear up this matter. I advised Magistrate Douglas A. Tate that a writ in the nature of discovery, jury trial on my own peers was submitted to Clerk of Superior Court 3, at which time Magistrate Douglas A. Tate advised me that he would look into it. I also demanded that Magistrate Douglas A. Tate dismiss the charges, at which time Magistrate Douglas A. Tate states he was not going to do that, but that he was going to enter a plea for me of not guilty at that time. I pled the fifth for the record. At that time, Magistrate Douglas A. Tate stated I could not plead the fifth in his court in violation due process of law, Fifth Amendment. Number 5. I stated for the record a contract has to be disclosed, as this is the premise for this claim, and without it there can be no claims. All law is contract. Whew. Woohoo. Number 6. On December 20th, 2019, a tax form 56 notice of rogatory appointment was exhibits judicial notice, legal notice of removal, was sent via certified United States Postal. It was received and signed for by a representative or clerk of Superior Court 3. Roman numeral 3 this time. It has not been honored nor answered. Sending in a tax form. I'm not going there. I'm here to read this, you guys. Don't make me laugh. On January 15th of 2020, a motion to compel discovery with exhibits was sent via certified United States Postal. It was received and signed for by a representative or clerk of Superior Court 3. It has not been honored nor answered. Number 8. On February 19th, 2020, an affidavit of fact notice of default judgment was sent via certified United States Postal. Dishonor due to incomplete, non-germane information provided regarding writ of discovery, evidence of fact. It was received and signed for by a representative or postage stamp clerk of Superior Court 3. Assigns were advised that certain documentation was requested under the rules and law of discovery and disclosure to make a physical inspection to verify and witness the same in order to prepare a defense to alleged claims. In accord with due process under the law, supported by sworn oaths and affirmation by the judges of every state, denial of discovery is in direct violation of my constitutionally secured rights to due process of law, which is a direct violation of your oath of office. This is a lawful notice that the said affidavit states as sufficient judgment and law. Failure to answer to the lawful affidavit, writ of discovery, evidence of fact leaves Howard County Superior Court 3 in a default status. Number 9. On July 24th of 2020, the averment of jurisdiction was sent via certified United States Postal to Howard County Courthouse Superior 3, Magistrate Douglas A. Tate, prosecutors Mark A. Hurt and Mark A. McCann, hereinafter entity. It was received and signed for by the representative or clerk of Superior Court 3. A time frame of 10 more, M-O-O-R, mind you, days, 10 was warranted for a response. Failure to answer the lawful affidavit, writ of discovery, evidence of fact leaves averment of jurisdiction, Howard County Courthouse Superior 3, Magistrate Douglas A. Tate, Mark A. Hurt, and Mark A. McCann in a default status. Number 10. On August 10th, 2020, due to incomplete, non-germane information provided in regard to the averment of jurisdiction, thus making the alleged summons, ticket, suit, bill of exchange, void ab initio, ipso jure, and ipso facto, the fact that this lawful request has not been honored nor answered, this default judgment is being claimed against Mark A. Hurt, Mark A. McCann, Magistrate Douglas A. Tate, and all other parties of interest mentioned herein related this matter. In absence of such response, affiant R. Razak Rashid Bey hereby inserts the record this default judgment upon and against above named respondents pursuant to the United States Republic Constitution. Their club has a constitution, you guys. So funny. For the record, subject matter was brought in on the advert of jurisdiction. Okay, no rebuttal. Let me move down here a little. Let it be known that Article 6 of the United States Constitution, by which all state and federal employees, agent contractors, etc., are bound by oath to uphold and support with the same obligations being affirmed by rulings of the United States Supreme Court. On August 14th, 2020, I sent the documents listed to Mayor Tyler O. Moore, Magistrate Douglas A. Tate, prosecutors Mark A. Hunt and Mark A. McCann, public servants Justin McKay, badge number 417. Oh, and all 26 others of them, you guys. An affidavit of non-response, an affidavit of fact, notice of default, opportunity to cure, affidavit of truth, affidavit of truth, affidavit of truth, through the postal, prepaid, and properly addressed envelope, certified mail, return receipt to me, requested, enclosed, and properly sealed at the Postal Service under the exclusive care and custody of the United States Postal Service of the state of Indiana. All right. Number 12. As of date, September 21, 2020, MC 1440. I have not received any written response to the documents I mailed on date September 16, 2020, September 17, 2020, or, let's see, it looks like, and then he says it was received and signed for by the individual clerk and representative for whom it was addressed, blah, blah, blah. I wonder why he hasn't received a response, you guys. Legal claims. For stop and identify issues, Fourth Amendment, see Brown v. Texas, 443 U.S. 47, and Collender v. Lawson, 461 U.S. 352. The court has no authority to reach merits, but rather should dismiss the action. Melo v. U.S. 505 F2D 1026. There is no discretion to ignore lack of jurisdiction. It's hilarious, isn't it, that there's lack of jurisdiction in his case, but yet when he goes filing, then all of a sudden he can invoke jurisdiction. This kind of illness, if there's like some special fund to help these people with this mental illness, I wish someone would tell me because I'd be happy to provide a donation to it. And then he goes on to cite a whole bunch of other cases that have nothing to do with anything and are all completely cherry-picked for the followers that he clearly has fallen for hook, line, and sinker. All law is contract. Therefore, in order for any claim to be made, the contract must be produced. For Magistrate Douglas A. Tate to imply that the writ in the nature of discovery does not have to be honored as a violation of my constitutionally secured rights to due process of law. The Fifth Amendment required that all persons within the United States must be given due process of the law and equal protection of the law. In so refusing to honor the writ in the nature of discovery and denial to the notice of default judgment, Magistrate Name has violated his oath of office to uphold the United States Constitution. Now, I'm not going to go in and read all of these different things that he did for what he's cherry-picked out of cases, including Thompson versus Smith, which is really sorry and sad that he's using that one. But regardless, the bottom line says here, as a magistrate who should be well-versed in law, now he's going to tell the judge doesn't know anything. Douglas A. Tate knowingly committed fraud, as he knowingly has been administering in capacity in which he does not have jurisdiction, delegation of authority, or judicial powers delegated from the legislature. Relief! Number 1, the enforcement of the following: the divine constitution and bylaws of the Moorish Science Temple of America, the Moorish Nation of North America, Act 6. What is this? Act 6. By being Moorish American, you are part and parcel of the said government and must live the life accordingly. Article 6 of the United States Constitution, Republic. The Treaty of Peace and Friendship of 1836 in capital letters, no less. AD classifies Moorish Americans as federal citizens possessing freehold by inheritance status. Truth A1. See Article 3, Section 2 of the Constitution for the United States of America. Number 1. I, Rashid Bey, demand due process as protected by the 4th and 5th Amendments of the Constitution of the United States of America. Republic. 2. I, R. Rashid Bey, demand the United States federal court stop these abuses of the colorable authority by the plaintiff as it pertains to this petitioner. Number 3. I, R. Rashid Bey, demand if any criminal charges be found, let them be placed upon the plaintiffs. Number 4. I, R. Rashid Bey, demand this United States federal court view this petitioner in my proper person as a Moorish American national, natural-born citizen of the land, and not as a brand Negro, black man, person, colored, African American, or any other slave title or nom de guerre imposed upon me for misrepresentation, actions, or other acts of misprision that a misdirected society may believe to be true. Got that? Number 5. I, R. Rashid Bey, do not, under any condition or circumstances, by threat, duress, or coercion, waive any rights inalienable or secured to the Constitution or treaty, and hereby requests the United States Supreme Court to fulfill their obligation to preserve the rights of this petitioner, Moorish Americans, and carry out their judicial duty in good faith by ordering plaintiff to be brought before the law to answer for their criminal and unjust actions. Number 6. All unconstitutional order or action associated with it or them to be dismissed and expunged for the record on its face and merits, or otherwise be brought before a legitimately delegated and competent court of law of international jurisdiction/venue. Number 7. All agents, state and federal officials, contractors, are to be informed of the law of the land, Constitution, and their obligation to uphold the same, and no longer be executed without action on the part of the sheriff for violating the same, and to be made cognizance of the recompense of colorable actions in their part by not adhering to the law. Is that right? That word does not look right to me. Anyway, if I mispronounced it, I'm sorry. 8. Any respondent, corporate, or natural party claimants, involvements to be found guilty in violation United States Republic Constitution, United States Code of Law, and in accordance with the law, is required by law to immediate recusal of his or her office. And he goes on to attempt to try to sue all 27 for $75,000 each on many different counts. So, for example, we have, I don't even want to go here. We'll just say that it's $75,000 per respondent. Trial by jury of my own peers was and is demanded. I declare under the penalty of perjury under the law of the United States Codes that the above is true and correct and to the best of my knowledge and honorable intent. Respectfully submitted this 6th day of October 2020, 1440 MC, and signed for by CrayCray. All right, there are 6 pages to this. I did the best I could to get it read quickly. It is insane. It will never work. It never has worked. And this is not his first rodeo. But I wanted for everybody to have the opportunity to see what this fool served in those 27 summons. All I have to say to you is, Rashid, Mr. Bey, you can look forward in this case to exactly the same thing you got in all of your other cases. 0. Have a good day.